Hey guys, today we're going to talk about expectation loss in the context of calculation of damages. Now, what is expectation loss? Expectation loss refers to damages paid by a losing party for his breach of contract, which is calculated based on the plaintiff's loss of a bargain, such as profits that he expected to receive if the contract had been performed, less the cost it would have incurred to earn that profit. The purpose of expectation loss damages is to put the innocent party in the same position as if the contract had been performed. So for example, I am a computer shop. I entered into a contract with a computer manufacturer to order 10 computers for $1,000 each. And then I intend to sell each computer for $2,000 each. In other words, my profit from each computer is $1,000. And then the manufacturer of the computers breached the contract and failed to deliver the 10 computers to me. So, under this contract, I expected to buy 10 computers at $1,000 each from the manufacturer and then to sell them at the retail price of $2,000 each. So I expected to make 1,000 times 10 computers. Therefore, the total amount that I expected to make from this contract was $10,000. The margin of 1,000, I bought it at 1,000. I intended to sell it at $2,000. So the profit margin per computer is $1,000. So I bought 10 computers. My expected profit is $10,000. So the expectation loss in this example will be $10,000, which I can sue the manufacturer for breach of contract. The courts have held that expectation loss and reliance loss are mutually exclusive to prevent double recovery. Reliance loss refers to losses that you incur in reliance that the contract will be performed. So for example, if you prepare or you incur costs believing that the other party will fulfill his obligations of the contract, and then he breached the contract, you wasted expenditure. This is called reliance loss. So traditionally, the courts have held that you cannot claim reliance loss and expectation loss because this will be double claiming. But Chitty on Contracts, which is a leading contract textbook, stated that what this means is that the claimant should not recover his gross profits expected under the contract and also the wasted expenditure incurred in reliance of the contract, which he intended to meet from the gross profit. Gross profit means the entire amount of profit, the gross amount, not the net amount. The Singapore High Court in Smile Dental Surgeons and OP3 International concurred with Chitty's position and held that the general rule that you cannot claim reliance and expectation loss does not apply where the loss of profits are claimed on a net basis. Net means after deduction. So the court held that where the claimant claimed for both the net loss of profits and the costs incurred to enable the claimant to earn that profit, there will be no double recovery because the loss of profits has already been netted off. And there will be no need for him to choose between one or the other because the expectation loss is on a net basis, not on a gross basis, unlike the traditional rule. Thanks for watching this video on expectation loss.